Welcome everybody to Chicago Autism Network's virtual parent workshop. Tonight, we're fortunate to hear from special needs attorney Brad Dems. Brad Dems joined Matt Cohen and Associates in 2017. He is from Michigan and earned a Bachelor of Arts from University of Michigan in 2009 and a Juris Doctorate from Wayne State University Law School in 2012. Brad's passion for disability rights and special education in particular comes from his experience working with and advocating for individuals with disabilities in various contexts over the past 2 decades. Prior to joining MCA, Brad spent 5 years working as a staff attorney for Michigan Protection and Advocacy Service Incorporated, where he represented families of children with disabilities in all stages of disputes with their school districts. Brad is also licensed to practice law in Illinois and Michigan. So I will turn the time over to Brad.
Okay, thanks, Kimmy, and hi, everybody. Thanks for joining us today. I should first say that I agree that Nando's Peri Peri is delicious, and everyone should go on those dates to support a great cause. So I'm here today to talk to you guys about special education during COVID and beyond. So what's been going on for the past year plus when your kids have been most likely remote, although I think some districts have had a hybrid model for a good portion of time. But in Chicago specifically, it's been remote until more recently. So I want to chat with you guys a little bit about that, some advocacy tips about what you can do to set yourself up for success when you go back to school, when your kids go back to school, and how to address some of the negative effects that might have occurred from remote learning. So I'm going to share my screen here. Okay. So first thing to talk about is addressing gaps in learning. So when I talk about some of the detrimental effects of remote learning, we know that not being in person, not being there in the learning environment is challenging for all kids, and definitely even more so for our kids with disabilities, children with autism specifically, but really all children don't get the same learning experience in person as they do remotely. I've heard from some clients whose kids love remote learning, but I think that's very vastly an exception compared to the rule. So gaps in learning have occurred, unfortunately, for a lot of our clients that we've talked to recently, and a lot of issues have come up over the past year. I'm hoping I can share some of my experiences and thoughts on that with you, and give you some takeaways that can help you advocate for your kids or your clients, as the case may be. Oops. I'm having an issue with the slideshow. I'm not sure what's going on there, but let me see. Oh. PowerPoint is not my friend today. Sorry about that. Let me try one more time to get this up. Okay. Is that better? Okay. I think that's good. All right, thanks for bearing with me. So thinking about your child's skills, learning, and where it was before remote learning started compared to where it is now, to the extent that you can gauge that on your own, it can be helpful to notify your school district of your perspective on things that your child either used to be able to do, skills that you saw that they were developing that now have either stagnated or regressed, and to really be honest about what you're seeing and what your concerns are. A good way to do that is to look at the IEP goals. These are the things that you and your school team have determined were appropriate to focus on in most cases. Um, and in those situations, you can sort of have a roadmap of discrete skills to look at and say, where did we expect the student to be at the end of the year, and where are they now? And if they're not where you expected them to be, uh, sure, it's possible that that your expectations may have exceeded reality. But if we start from a place of assuming that the IEP was written accurately and reasonably in terms of what you were expecting, and you haven't reached that point, then you have a good reason to raise a concern. Um, and the fact of the matter, like I said, is that during remote learning, a lot of skills have probably stagnated or regressed. So it's not outside the realm of possibility or reasonableness for you to be raising issues about uh, where your child is now compared to where they were before remote learning started. If you've kept documentation of what your child was working on or areas they've struggled in, how you've assisted them, all that information, all those details are good to share with the school as part of a request for evaluations, maybe, and we'll talk a little bit more about that in a few minutes. If you haven't kept that information, it's never too late to start, just based on what you're observing at home. Even if they've already gone back to school, you can always keep track of what you're seeing in the home setting when you're working with them on homework or on social skills. Sometimes those things are easier to observe, right? You may have a social skill goal or a speech goal uh, related to social pragmatics or interactions uh, between between your child and others. So that could be you, could be siblings or friends. So whatever you're observing as far as their abilities is important to report back to the school district. And just as an overall point, when I talk about communicating with your school district, I'm suggesting, or you should presume that I'm considering it in writing. We always advise parents to communicate in writing so that the school is on notice of what issues you're raising, and so you can point back to that and demonstrate when you made them aware of things and how they did or didn't respond. So if you do have concerns, there are several things you can do other than just sharing the information. You can request an IEP team meeting or a 504 meeting if you have a 504 to discuss your concerns and your child's current needs. You should not only be advocating for the services that were in the IEP previously or the instruction that was in the IEP previously, but also potentially more intensive services to allow your child to not only get back on track, but to get back to that place that you expected them to achieve. And that could require more intensive services than they received during the previous year. Because they've regressed in this scenario. So they're at a place now where they need more, right? Because not only are they trying to gain what they should have gained, if not for the loss of time, but they're also learning new skills beyond that moving forward. So this could include tutoring, instruction, and related services, really with whatever's necessary to accomplish getting your child back on track. And it could be before, during, after school. It could just be a change in, minutes of social work, for example. If they had 30 minutes before, maybe now they need 45 minutes per week of social work services or more, right? It's about figuring out what's needed and advocating for that. You could also get after school or summer school services if it's not possible for your child to receive additional services during the school day. And that's harder to get, but if it's really the only time and it's clear that your child needs it, then you have a good argument to make that they're entitled to that. So we've sort of been talking around this term called compensatory education. So I want to just highlight that for a minute and tell you what that means and what our perspective is on that. And by the way, I do see that folks are responding in the chat with questions, and that's great. I see Mo, hi Mo, is asking if the PowerPoint will be available. Kimmy mentioned that the whole presentation will be recorded and available later, and I can also make the PowerPoint available to share. Otherwise, for questions, I think we're going to hold off and try and address them all at the end. So please, feel free to keep typing them in so we can get to them later, or if you prefer to hold your question and ask it live at the end, you can do that too. But I'm not going to go in and answer every question as they come in. So back to compensatory education. This is essentially a remedy for a school district's failure to provide appropriate services. The intent is to place the student in the position that they would have been in if the district had provided appropriate services in the first place. So what we've been talking about as far as more intensive services when the child goes back to school, discussing with them your concerns about regression or stagnation of skills, it could all be considered the basis for a request for compensatory education. But school districts may bristle at the term compensatory education because it's often seen as a remedy for a violation. So comp ed is something that we ask for in hearing requests all the time, basically saying all these issues that we've raised have resulted in the child not receiving an appropriate education for the past year, and therefore they need additional services to compensate for what they missed. So that's something that's awarded frequently by hearing officers as part of due process hearings. But because of that, it may have a negative connotation for the school district. So just thinking about advocacy efforts for your child, it may be more appropriate to just not ask for compensatory education, but essentially say, this is where my child is now, this is what their current needs are, and you, school district, are required to meet their needs as they are now, regardless of what happened in the past. So to be clear, you're not ascribing blame to the school district, even though they may be blameworthy, but that could lead to more defensiveness and lack of cooperation. So if your goal is really to get them the appropriate services now, put it in that context in your request rather than saying you did something wrong. So you can see we'll talk about that a little further down on this slide, but just to backtrack a little and be clear, when you're talking about compensatory education, the threshold is whether the deprivation was significant enough to cause a lack of progress or educational benefit. So missing 1 week of speech language services is probably not going to be enough to qualify for comp ed. If a service provider was absent that week and they couldn't get to it, that's not going to be enough for comp ed. You really have to look at, has there been a significant lack of progress and loss of educational benefit? Now, if they stop providing speech language services or other related services altogether, then that's going to rise to the level of warranting compensatory education. Now, there are multiple ways to calculate comp ed, but by far the most common is called the qualitative approach. So we're not looking at a 1-for-1 replacement. Your child missed 120 hours of speech language services, so they're entitled to 120 hours to replace that. That would be a quantitative approach, which is sometimes used, but far more common is qualitative, which really looks at how do we place the child in the position they would have been in if not for the district's violation, if not for an absence of appropriate services. So that could be less minutes, but more intensive services. It really could be any combination that gets your child back to that place that they would have been in, if not for an absence of services. So now jumping out of the comp ed discussion and just looking at the return to school more generally, a lot of these points come from guidance that we've received from the State Board of Education. ISB is the acronym there, among hundreds of acronyms in the alphabet soup that is special education. And you'll probably hear more of them today. And so I'll try and identify, if I just say an acronym, I'll try and identify what that means, but there are quite a lot of them. So ISB, the Illinois State Board of Education, has provided several documents of guidance over the year plus that we've been in our COVID reality. And they've suggested that school staff should identify learning standards that weren't covered during remote learning and prioritize a review of those critical standards that weren't addressed during remote learning when kids go back to school in person. So you may have, if you're back in person already, you may have heard from your school about what they're prioritizing. That's in line with the state's guidance, but it doesn't mean that that they should disregard other things that aren't part of these critical standards. It should be this plus whatever else your child needs. In addition, just considering concerns that you may have about your child going back to in-person learning after such a long time off, it could be helpful to talk with the IEP team about a transition plan to help your child adjust back to the school environment. We know that a lot of youngsters with autism are routine bound or like to know what to expect, what's coming up. So giving them social stories or an opportunity to go walk the halls of the school and sort of see, okay, I'll be going to this room and this room. Maybe see their teachers in person and say hi. That could be helpful. Also, if they need to return gradually, 1 hour a day, 2 hours a day, whatever they need, you and your school should be thinking creatively and collaboratively about how to make that a productive transition back. And you should request evaluations from the school district to determine your child's current functioning in any areas of concern, right? Because like we mentioned, you can take a look at that yourself to whatever extent you can, but you, in most cases, you, the parent, are not a trained educator. You certainly know your child better than anyone, but you may not know the specifics of how to identify their skills in every academic or social or functional area. So you're well within your right to request evaluations at any time, and you should do that in writing to the school district and be as specific as you can about what you're looking for and what your concerns are. So a couple slides as we go here about evaluations in general, now that we're talking about that. Written informed parent consent is required for all individual evaluations and reevaluations. And that means that the school has to tell you the specific evaluations they're conducting, in what categories or domains, and give you an opportunity to ask questions. And then once you're informed about what the evaluations are, to provide your consent for evaluations to take place. No evaluations should take place before parent consent is given. And you can withhold consent if you're concerned about evaluations taking place. There are several reasons why you may be concerned. I don't want to get too far down that rabbit hole now, but I would just advise caution and that you consider what the concerns are and whether they're reasonable. And again, there are many reasonable uh, causes for concern, but you don't want to reject evaluations out of hand because that may be damaging to your negotiation ability in the long run if the school district can claim that you weren't being reasonable or partnering with them. So that's just a blanket caution. But again, I wouldn't be concerned about raising issues or asking questions if you have them. That's well within your rights and reasonable to do. So in conducting evaluations subject to the IDEA, there's another acronym, that's the Individuals with Disabilities Education Act. That's the law that governs everything that we're talking about in terms of your child's rights. They have rights to special education and to a free appropriate public education. You may have heard that referred to as a FAPE. That is, all those rights originate within this law called the IDEA. So in conducting evaluations, districts are required to use a variety of assessment tools to gather functional, developmental, and academic information about your child. So remember that education is not just academics. It's not just reading, writing, and math. It's also their functional performance, their social skills, their occupational therapy skills, executive functioning skills, ability to organize and time manage, for example. All of these things are part of their education and what they're entitled to receive services for if they need them, and certainly areas that need to be evaluated. School districts also can't use a single measure or assessment as the sole criterion to determine eligibility for special education. They can't just look at an IQ test on its own. They also have to use technically sound instruments that assess the contribution of cognitive and behavioral factors. So that's getting a little in the weeds, and we don't have all the time in the world today, so I don't want to spend a ton of time on that. But I guess I should also say, if you have questions that we aren't able to get to today, we'll try and get them all at the end. But if anything is unanswered, or if you log off after this webinar and think, oh shoot, I should have asked that, you can feel free to email me anytime to ask those questions, and I'll give you my email at the end. That's a little teaser to keep you around until the end. So the scope of evaluations. Evaluations must be non-discriminatory, and they must be provided in the language and form most likely to yield accurate information on what the child knows and can do, again, academically, developmentally, and functionally. Evaluations have to be completed within 60 days of parent consent. There can be some flexibility on that, especially in cases over the past year. The timeline was still required to be 60 days, but there was some need for flexibility in light of COVID and the limitations that placed on the ability to conduct evaluations. So there's always the ability to negotiate and agree to extensions if appropriate. And important to note that a parent request for evaluations isn't automatically consent, because remember, they have to tell you what evaluations they're going to do and give you the ability to provide informed consent based on that information they share. So if the school won't do an evaluation due to COVID, or has refused in the past to do an evaluation over this past year, the state Board of Education has said that while remote is preferred, live in-person evaluations are appropriate and allowable following safety requirements, whatever they may be at the time. Now that we're mostly back in person or hybrid, this shouldn't be as much of an issue, but if they're still saying that there are components of evaluations they can't do, you should feel emboldened to push back on that and remind them that they are allowed to do that with appropriate safety precautions in place. Reasons you may have sought an evaluation during remote learning. Again, this sort of goes back to some of the things we discussed earlier, so I won't go into too much detail about this one. And then I wanted to just mention briefly independent educational evaluation. That's an IEE. Uh, Parents can request an independent evaluation if they're dissatisfied with a district evaluation. So if the school district conducts an evaluation, you get it back, you think, this doesn't describe my kid, or he was having a terrible day, and the evaluator even said that there was, they're not sure about the validity of this because he was refusing to participate. You can request an independent evaluation separate from the district. They would pay for it under the law, but you would be able to select your own evaluator, subject to some limitations that the district can place on the cost and other things. But they can't dictate who the evaluator is, and you can always talk to them about potentially exceeding cost limits if it's necessary to do so. The caveat, though, is the district, they have to respond to a request for an independent evaluation by either agreeing or filing a due process hearing on their own, essentially saying, our evaluation was appropriate and we want you, hearing officer, to declare that that's the case. So those are the two divergent paths that could happen when you request an IEE. IEEs can be especially helpful during the pandemic because schools most likely have less data than normal and less than you as the parents have, being with your child all day, every day. So that elevates the importance of independent data. And in addition, there are sadly more kids that have been in crisis over the past year. And when we say skipping steps in LRE, that means they may need a more intensive placement right now, rather than waiting to be able to try going back to the public school or to a separate type of classroom. And you may need an independent evaluation to determine that. And by the way, you're always entitled to get your own evaluation and pay for it out of pocket. The district's required to consider it. They don't have to implement it, but they are required to consider that. I'm going to skip this one, just some good points about what IEEs can accomplish, and feel free to go back and look at this slide later. Already mentioned this a little bit, and I'm going to slide ahead here. So let's talk a little bit about addressing COVID precautions now that kids may be, most likely are, going back to school in person. Some disabilities make it harder for children to understand or comply with the precautions, like wearing a mask or social distancing. We'll talk about both of those in more detail on the very next slides. Important to note, schools can't exclude children from in-person learning due to these disability-related issues. They can't say, Johnny can't wear a mask, so he can't come to school, right? And we'll talk, again, more about that shortly. But as a preliminary matter, if you have concerns about your child's ability to follow precautions or understand the reason behind them, you should put them in writing and request accommodations. It would be helpful to have letters from physicians or doctors who know your child to support the accommodations that you're asking for. And it's also a good idea to ask that these issues be noted in the IEP or in a behavior plan, so you can really establish that these are disability-related issues, not just non-compliance, right? He's not just pulling his face mask off because he doesn't believe in the efficacy of face masks and it's a protest. It's because he has a sensory issue or just doesn't understand why it's on there. So it's important to get that context noted in the IEP or in a behavior plan. So face masks specifically, individuals with a condition or a medical contraindication that prevent them from wearing a face mask, it's required that you provide documentation from a healthcare provider to demonstrate that that's the case, to document that that's the case. And if you do, it's a reasonable accommodation that your child be able to wear a face shield, but in that case, social distancing must be strictly enforced. And the Illinois Department of Public Health has made clear that a face shield is less efficacious or less protective against the spread of COVID than a mask is, but it is allowable as an alternative if masks can't be worn. Although I recognize that if it's a sensory issue specifically, having a face shield on is probably not going to be any better than a mask. Students who are, and by the way, as I mentioned before, this comes from state guidance from the Illinois State Board of Education, saying students with an IEP or a 504 who are unable to wear a face mask or face shield, so either one, cannot be denied access to in-person education if it's being offered to other students. So staff who are working with a student who are unable to wear a face mask or shield should wear protective equipment themselves and maintain social distance as much as possible. But if a child can't wear a mask, they still have to be given the opportunity to go to school in person. Again, face shields can be used as a substitute in circumstances where teachers need to show facial expressions, or it's important for the student to see the mouth moving. Another alternative to a face shield is a clear face mask or video instruction, which could be, just remote learning. But if you want your child to go to school, they have to be given that opportunity. Social distancing in the most recent guidance is defined as 3 to 6 feet. 6 is optimal, but 3 feet is okay. Strict adherence to 6 feet, though, must be maintained when face masks are taken off. So that includes when kids are eating, or in the cases we just discussed, if a kid can't keep a mask on. If your child does have difficulty with social distancing or understanding personal boundaries, that's something else that's important to note and to put into IEPs and behavior plans. And peers should be made aware of that too. Right? All of our children, we've been instructing them for the past year, don't get too close, keep your mask on, all these things. So if kids see a peer of theirs without a mask on or not social distancing, they might be concerned. They might be scared about how that might affect them. They may just not understand. So it's important to be sensitive about that, just like schools often are in explaining to children the differences between them that they may notice between them and their peers with disabilities. So finding a sensitive way to explain why a certain child can't wear a mask is appropriate and would be reasonable to expect your school to do to help ease that transition back to in-person learning. A lot of schools, including CPS schools, are using cohorts, essentially groupings of students and teachers in smaller groupings than full class sizes in order to limit or minimize the spread of COVID. But it's important, again, from ISB, important to consider services for students with disabilities when developing cohorts so that they can receive those services within the cohort, but also have the opportunities, equal opportunities in line with disability rights and other civil rights laws. So service providers like speech language pathologists or social workers, if they're not a part of the cohort because they're a more general staff member who goes throughout the school, different classrooms, maybe even different schools, the school can't say you don't get social work anymore because that's someone outside your cohort. They have to provide that service within the cohort, and the state has described mitigating measures that should be taken into account, which includes, as always, wearing appropriate face masks and PPE. So to be clear, cohorts are not a barrier to related services in a student's IEP. There's no excuse for not providing related services that are in your child's IEP. even if they're in a cohort. Opting out of in-person instruction. So a lot of school districts are providing the opportunity or the option for parents to select to keep their child home and continue with remote learning full time, if that's what they're more comfortable with, or if that's what's necessary for medical reasons, and especially families of students who are at increased risk of severe illness or who live with people who are at increased risk must be given the option of remote instruction. So if your school district is saying generally, we're not providing remote learning anymore, if you are someone yourself who is at risk and concerned about your child going out and bringing something back home, or if your child is at risk themselves, they must be given the option of remote instruction. So separate but related to that is a concept called homebound instruction or home hospital services. That's separate from the opt-out and continuing with remote learning. And even before COVID, there was this concept called homebound instruction that still exists. It's in the law, and it says that if your child has a medical or psychological condition that makes it unsafe for them to attend school in person, you can request homebound services and submit a written and dated letter to the school. Again, you're required to provide that letter from a physician describing the diagnosis, why they're requiring homebound, and the expected amount of time they'll need to be at home, or the duration that homebound may last. And that's not a hard and fast deadline. You can get a second letter and a third, and ad infinitum, extending that deadline if necessary. So unlike remote learning, homebound is based on this individualized determination about your child. It's not like all children being kept at home because of COVID. This is specific to your child and the safety or lack of safety of educating them in the school setting. Homebound instruction can include individual instructors coming to your home, service providers, social workers coming to your home to provide services. School districts may not agree to that during the pandemic, but just like providers who are in the school setting providing services, if it's something that your child needs, there's nothing in the law or in the state guidance saying that they can't provide homebound instruction. It could also be virtual or a combination depending on your child's needs. It could be meeting at your home or at another safe location, like a library if they're open or when they're open. And you should meet with your child's IEP team to develop a plan for homebound. Now, when your school district doesn't agree to provide appropriate instruction and services, or if you have a difference of opinion about what's appropriate, you are entitled to file a request for mediation or a request for a due process hearing, or a state complaint with ISB to try and address that issue and hold the school district accountable for what you see as potential violations of your child's rights. There are a lot of reasons why parents may request a due process hearing or mediation. And to be clear, the difference between the two, mediation is a more informal process where a mediator is appointed who's a trained professional whose position is to provide sort of a neutral go-between for the parties to try and facilitate a resolution of their dispute. But it's not a binding procedure. The mediator has no authority to order anything. It's really up to the parties to come together and reach a conclusion. And my dog wants to play. Sorry if you heard that. So that's mediation. And by the way, everything that's discussed at mediation is considered confidential. And the purpose of that is to try and encourage the parties to speak frankly and honestly and try and reach a resolution. That doesn't mean you should go in there and admit things that you might be, you know, worried about admitting. And by the way, I'm not suggesting that anyone, uh, you know, lie or do anything unscrupulous in a mediation, but you don't have to share your thoughts on strategy or your potential plan to file a due process at some point in the future, just because what's said is confidential. If you're at the stage of mediation, you're hoping to resolve the issue, but if you don't resolve it there, you still have the right to file a due process hearing or file a state complaint with ISB to try and address those issues. A due process hearing it's an administrative hearing, but for all intents and purposes, it functions like a trial. You have witnesses who get cross-examined by you and by the school district and answer questions, give testimony about their experiences working with your child's progress or lack thereof, what their needs are, and try to establish your position that what you're asking for is reasonable, appropriate, and necessary for your child. Frankly speaking, the due process hearing system is extremely complicated and onerous, even with legal representation, but certainly without. Your chances of success if you are going to a hearing on your own are much lower than if you have an attorney there to represent you. This isn't a sales pitch. It's just unfortunately the reality of the situation. Many times we've heard of cases that are going down a rocky road or have led to a bad result because parents are representing themselves, which is unfortunate that the system is such that it's not easy for parents to navigate on their own when it gets to the hearing stage. But it's certainly advisable to have an attorney to counsel you and to represent you if you get to that stage. Doesn't mean that parents haven't been successful doing it on their own. There are certainly a lot of capable and tenacious parents out there who can advocate for their child, but even so, it can be very difficult, especially because you can expect that the school district will be represented by an attorney, whether you are or not. So that can be scary to go into that situation without backup, without support. Of course, we are ready, willing, and able to hear about your case and see if it's something that we can assist you with if you're at that stage. If you're before that stage and you want to try and avoid getting to that stage, we can talk to you about additional ways to advocate and set yourself up for success. You can also find more information on the various types of dispute resolution at this link. If you don't have time to jot the whole link down, just go to isb.net and you can find the page for dispute resolution fairly easily. So that's the end of my prepared slides. I'm going to stop sharing now, and I think we're at about 7:45 on the dot. So if we have questions, now's the time to ask them. Kimmy, I don't know.